time and people can just join afterwards if they're not on time.
Yes, it's all in.
Okay, are you
all in
everyone
your
happy?
hand.
Everyone happy? Can we start? You happy?
I'm ready
Okay.
if you are.
Okay. Good afternoon, ladies and gentlemen. As I've just said, it feels a bit awkward to talk to people that you can't see apart from the panelists. But on behalf of our Dean, Professor Lawrence Juma, that unfortunately can't be here, and on behalf of the law faculty, we would really like to say a warm word of welcome to all of you who've made the effort to attend this wonderful discussion with the former Deputy Chief Justice, Honorable Justice Dikgang Moseneke. And this discussion is quite interesting. It's called the intergenerational. And if you look at the panelists, you'll see we are fortunate. We've got 2 males, we've got 2 females, we've got 2 final years, we've got a penultimate student, we've got a 3rd-year student. And this wonderful conversation with Justice Moseneke and the law students. So what I'm going to do is I'm first going to introduce you to the panelists, and then I'll briefly give an overview of the program, and I'll then do a short introduction of Justice Moseneke, and then I will invite him to give a short overview and introduction on the book, about 15 minutes or so, and then our students will start their conversation with Judge Moseneke for about 30 minutes or so. Then we'll have a short question and answer session. But I'll take you through the program just now. So first, let me quickly introduce the panelists to you. As I've said previously, we are fortunate to have different students here from different year groups. We've got our 2 final year students. We've got Lisa Nyola, she's a final year LB student and also the Law Student Society representative, and also one of Professor Kruger's constitutional litigation students. And then we also have our another final year student, Zenamile Zungo, and she's our current president of the Law Students Council and also a student in the constitutional litigation class. So welcome to the 2 final years. And then we also are fortunate to have a penultimate year LLB student, Vuyani, also Democracy Works Academy Fellow of 2020, and also at the moment he's the vice chairperson of the Black Lawyers Association student chapter at Rhodes. And then our youngest student, our 3rd year representative, Washington Mutaringe, is majoring in law and organizational psychology. And he's also currently the president of the Ntuko Legal Activism Society. To our 4 student panelists, thank you very much. We know it's almost last week of term and you're already getting excited about exams. So thank you for making yourself available to take part in this wonderful conversation. Briefly, overview of the program before I introduce our guest of this discussion. We'll, after I've done the introduction, we'll give Justice Moseneke about 50 minutes or so to give us a short overview or introduction of his book, the All Rise, a Judicial Memoir. And after that, we will allow the students to enter into conversation with him. Our 4 student panelists, there's also afterwards a question and answer session. And can I please ask you, if you scroll to the bottom of your page, you'll see that there's a chat option as well as a question and answer session. The question and answer session will be facilitated by our previous dean, Professor Kruger. And if you would like to raise a question, please make use of the question and answer session rather than the chat box. So I'll just remind you of that. So when we start with our question and answer session that will be facilitated by Professor Kruger, just remember to make use of that question and answer session. So that is our 4 panelists, overview of our program. And yeah, so now it's my privilege to welcome our guest of honor, Justice Moseneke, also quite important honorary graduate of our faculty and Rhodes University. And some of you might not know it, but also one of the country's longest serving deputy chief justices after serving under 3 chief justices to take part in this discussion this afternoon. And for our students who are starting soon with their professional degrees, I think it's also interesting to know that Justice Moseneke started his professional career also as an attorney's clerk way back in 1976. Later, he spent 5 years as an admitted attorney, and it was only really a few years later in 1983 that he was called to the Pretoria Bar. He also served on the technical committee that drafted the interim constitution of 1993. And in 1994, he was appointed deputy chairperson of the Independent Electoral Commission, which conducted the first democratic elections in South Africa. He then became a judge in the Constitutional Court, and in June 2005, became Deputy Chief Justice. In 2013, Judge Moseneke was appointed Acting Chief Justice during the long-term leave of Justice Mogoeng Mogoeng. He has made an exceptional contribution in the development of the jurisprudence of our country, and in particular, the groundbreaking and progressive judgments he has penned relating to affirmative action, property law, in respect of land rights, expropriation, and the constitutionality of parliamentary rules. Judge Moseneke retired from the Constitutional Court in May 2016, also the same year that he published his highly successful personal memoir, My Own Liberator, in 2016. With this new book, which is the subject of our discussion this afternoon, All Rise, a judicial memoir, his focus shifts to a judicial memoir, where he highlights key aspects of governance in South Africa in the first decades of the existence of the Constitutional Court. All Rise covers his years on the bench, with particular focus on his 15-year term as a judge at the South Africa's apex court, the Constitutional Court, including as the Deputy Chief Justice. His insights into the Constitutional Court structures, the personalities peopling it, the values it embodies, the human dramas that shook it, and the cases that were brought to it make for fascinating reading. Advocate Anton Katz, SC, who has appeared on multiple occasions before Justice Moseneke in the Constitutional Court, describes the book as follows. Despite its serious tone, All Rise has also the occasional humor and cheer and demonstrates Moseneke's ability, even in a limited way, to laugh at himself. In his almost 15 years as a Constitutional Court Justice, Moseneke was part of the decision-making in 411 written judgments, of which 273 were unanimous judgments. He wrote more than 50 substantive judgments, 15 of which were dissenting judgments, and participated and co-decided many thousands of applications. In 2018, Moseneke received the Order of Luthuli in gold, the South African government's highest national honor, for his exceptional contribution to the field of law and the administration of justice. Judge Moseneke is known for his commitment to social justice and human rights for all South Africans, as enshrined in the Constitution. This judicial memoir would not have been possible if I had not been privileged by my country to serve its people as a servant of the public. His book, Dedication, begins. I dedicate this memoir to all the people of our land and of Africa who deserve respect, freedom, and social justice, absent which I pray they will know and will revolt so that they rise. Judge Moseneke, warm word of welcome to you, and we look forward to the conversations this afternoon, and we invite you now to proceed with your short overview and introduction of your book, All Rise, a Judicial Memoir. Thank you.
Well, Professor Helena van Coller, a recognized former Dean, Professor San Creer, with whom I've interacted some time in the past. And I'm excited to see all you young people, Washington, Taringe, Vuyani, Njishe. How wonderful to see you. And I'm looking forward to us having a debate and a robust discussion about the issues that arise in the book. All Rise is the call that is made in every court in this country. Every morning, every afternoon when the court resumes. At its most common level is a call to duty, which lawyers and judges use to call everybody to attention. If you like, symbolically is the beginning of resuming the duty of doing justice. it is the time when everybody commits to engage into a process that will produce goodness, just outcomes. So therefore, it is a call to have justice served. And that is the most superficial meaning of all rise, I must say. But all rise at another level invites all of us really to assume layers, varied layers of accountability, of responsibility. And that responsibility sits, for instance, in what we do in order to make sure that we produce a just society, particularly in the light of our history of colonialism and apartheid, of exclusion and oppression. So it is an invitation for us to take a breath and to look at the back for a while. And for that reason, it's a history book. As the book starts, it takes you back to the time just before 1994. It's focused obviously on the judicial function. It's a judicial memoir. So a memoir would tell a story about an individual or individuals. So yes, it tells you a story of my movement into the judiciary and up to the end, at the point of my retirement. But it also tells you what happened to the judicial system. Now you will know, and you'll see it in the book, before 1994, nearly 98% of all judges were white males. So in effect, it tells you something larger than that, and it is this, is that the colonial arrangement and the apartheid arrangement was really hinged on white male power arrangements. Not even white women made the cut. There were only 3 women judges in 1994. And the rest, as I say, were white males. So it was a power arrangement that was male-centric, and that was white male-centric. And that was the reality that was we confronted in 1994. And it's an inheritance, it's a legacy question from colonialism and apartheid. And the real question was, what is then to be done? And we did a number of things in an attempt to try and change that situation. And I record that as history for you young people, to say, having found the judiciary as it was, and having found the law as it was, one of the first things that happened was, of course, to introduce constitutional supremacy, which really meant that Parliament could not make any law. Remember, in the past, the colonial and apartheid arrangements were that Parliament was supreme. And if Parliament said, both you, Washington, and Vuyani were not entitled to go and study at Wits, that was the beginning and the end. And in fact, you were not allowed during those times. You needed a special ministerial permit to be a student at Rhodes University, or at Wits, or at UCT, or wherever else. And the universities were specially set aside for African people, and people who were classified as colored, and people who were classified as Indian. So with a parliament like that, it was important that we change that and agree and identify the Constitution as a supreme law from which will flow all other law. And in the book, I show you that, in fact, in 1994, we found common law there and indigenous law there. And I repeat that indigenous law, common law, is a colonial imposition in the sense that it is not law that was homegrown. That is why I had to pass English 1, Latin 1, and Afrikaans Nederlands 1, because I had to access basically foreign sources. Suddenly I had to read a whole variety of foreign sources like De Groot and Van der Linde, and on we go. and Groeneberg, because it was really what it was. It was law, which was an amalgam of law that originated in Holland and law that were in the 16th century and law that originated in England. And that became the common law, and it was common to the rulers, but never common to the ruled. In other words, those who were colonized. And in the process, of course, you know that indigenous law was crowded out and became quite an unuseful piece of law because, in fact, it had never found the space to grow and to find and to adapt as the years went by. So over 350 years, indigenous law was crowded out and cramped and stunted, and it had little room for growth. But in 1994, the Constitution gave new lease of life to both the common law and the constitutional and indigenous law, provided they remain consistent with the values of the Constitution. And the book takes you from there with the formation, the creation of the Constitutional Court, why it was created. The book shows you the place of the High Court and its role, its powers, and the hard work which judges of the court have to do in order to keep the courts going. And you need to look at your screen every day, you'll see how hard judges and magistrates work. And I take you through the court structure and explain to you the magistracy, its origins. In colonial times, there were more offices for administration, and how they've evolved, and how we have, under the new arrangement, tried to make them to be actually places which dispense justice. Because remember that probably 80 to 90% of South Africans find their justice or injustice in the magistrates' court. Only a small percentage actually gets risen up to the High Court, Supreme Court of Appeals, or the Constitutional Court. And the book takes you step by step through from the formation of the court, building of the Constitutional Court building, a new culture that we try to induct. How do we write judgments? And what are the power relations amongst the 11 judges of the court, or even the 5 judges of the Supreme Court of Appeals, or the 3 judges in the High Court, or single judge courts. And I take you through how in the new system, judges are now appointed. In the olden days, the Minister of Justice appointed all judges. And now there was a new system, which was more inclusive, where all parts of the legal family sat, whether they are from the academy or they are practicing advocates or attorneys or members of parliament and so on, and ordinary citizens. So it's a much wider body that actually chooses judges. And the president is obliged to appoint somebody who the JSC says may be appointed. Then the book takes you to the Chaskelson Court, takes you through the Langa Court, the Nobo Court, and the Mogoeng Court. And of course, in all of those courts, I was a fly on the wall. I could see the goings on. And therefore, I felt that I owed to you, posterity, and to the public at large, an account of what happens. This also because judicial memoirs are very scarce in South Africa. Part of a tradition that we inherited, mainly, I think, principally from the United Kingdom. Judges work, retire, and they go away. And you never hear of them again. And the culture was almost like a ritual for passage to adulthood. You never come back and say what happened. So judges would come and do their work and go. And the last judicial memoir we had was written, a full-blown memoir, was written by Chief Justice Rhodes. He was the Chief Justice of the Transvaal of the time. And I felt, well, that was around 1890, thereabouts. And I thought I was going to write something fully. Then the book, of course, as besides history, it tells you about the jurisprudence. What happened? What cases were decided? It tells you about the background. For instance, the more there was contestation within the ruling party, the more the cases started flowing to the courts, which dealt with political contestation. Then you saw courts increasingly be invited to make decisions on the exercise of executive power, of legislative power, on whether certain things, on whether tenders have been granted properly, on whether parties in their internal democracy have acted properly. So everybody started coming to the courts, and all the parties came to the courts, and the court became the place where all those disputes had to be resolved. And I move on with the book until I take you to, at the end of all that, with all the jurisprudence and the decided cases and the background in the entire country, I take you to my retirement and life as a Dimeni. That's arbitration I did just post my retirement. And it is important at many levels, but more importantly is look at the honeymoon period where we started with Nelson Mandela inducted as president, when nothing seems to would go wrong. And then life as a Dimeni. And before that, I take you to Morogoro for you young people to give a bit of a history of the liberation struggle and the high values that were observed in a place like Morogoro, where people produce their own food. They tilled the soil. They produced their own meat. They made their own furniture. They drew water and piped it up to where they lived. And they built a school called Solomon Mahlangu Freedom School, which today is a university in Tanzania. That's how well built it was. Brick by brick, stone by stone, and the freedom fighters built a place. So the question I ask, what happened? How do we get to life as a Dimeni? Total, fulsome disregard for human life, respect for the vulnerable, etc., etc. And you can extend that theme to the rest of the country and ask the question, what happened? So that is All Rise. And it is properly dedicated to all young people, as you heard from Professor van Coller, in this country, all young people in Africa. And in the book, I've shown you just how in this country and other countries on our continent, leaders have disregarded the people quite often. And that you young people would know it when that happens. And you would not tolerate it. And my hope is that then you will all rise. And I'm talking about this in a peaceful context, but a clear context that says we will not accept injustice. Perhaps because when I was young, I did not accept the injustice of colonialism and apartheid. And I went to prison for it. And that young people would know when all these things are evaporating and do their best. That's an overview of All Rise. So if one day find time and the energy and the space, and you go and read it, that is sort of the bare bones of the book. It has light moments. It makes judges human. And it shows you that they are human beings doing a public duty. And they haven't fallen from any heaven by any chance. Thank you.
Thank you very much, Judge Moseneke. And I think it's now time to invite our young people to give them the opportunity to engage with you in conversation on certain issues. And we'll try and follow the program. So our panelists, please feel free to ask your questions and engage with our esteemed guest here and enter into conversation on the various topics. And firstly, Senamile, you are the first one, and you can kick off our conversation session. Thank you.
Thank you, Prof. Ankala. Justice Moseneke, thank you so much for All Rise. It's an incredible memoir, and it's something I wish that all law students could read. In the book, you detail the court's commitment to enforcing and protecting the rights of the most vulnerable groups of society. The overlapping of social and political identities often means that it's women, specifically Black women, who are the most marginalized. And during your time in the court, it was held that legislation criminalizing sex work was not unconstitutional in SB Jordan, and that the exclusion of unmarried persons from maintenance benefits under the Maintenance of Surviving Spouses Act was not unfairly discriminatory. And these judgments have been criticized as having an adverse effect on women's social security. So my question is twofold. Firstly, what is your take on the Constitutional Court's jurisprudence on gender equality? And secondly, under which circumstances do you deem it necessary or appropriate for the court to revisit its precedents?
Senamile, good afternoon, and thanks for being part of all this. This is what All Rise had hoped for, to spark off a discussion amongst young people and to question some of the things that we've done in the past. I hope they'll embrace a few. I hope there's some good things we did, not only the bad ones. State versus Jordan is an interesting case. Let me tell you a little about it. It was decided just when I had been appointed to the court. So I did not sit in the case. In other words, it was delivered when I had been appointed, but it was heard before I was appointed. So I was not one of the judges who sat in there. The court was narrowly split, if you remember. And maybe if I was on the court, I would have voted for the legalization of sex work. So I'm at liberty now to tell you, now that I'm off on the court, I certainly would have voted for a decision which is different from the one that the court arrived at. But that is not enough. The question is that the court did get there. And it was an early court, it was struggling. Remember, the Constitution does all sorts of things around race and colonial power structures, but it also, we often forget that apartheid was also about patriarchy. It was about male hegemony. I mean, there were laws that punished same-sex relationships. Up to 1994, we had to strike them down. Remember that there were laws that still required Sunday Observance Act, for instance. You could not go and play soccer or rugby or something on a Sunday. There were laws that did a whole range of things that all were reeking of the past. And the prohibition of sex work is one of those. And it has and it's not only on a racial level. In society in general, it also has that backdrop of men thinking that it's all fine for them to go out and solicit some happiness if they so they think, but it's all wrong if the women offered it and for remuneration. And you know that the punishments were always on women and never on men. Now, excuse me, there's no room for that kind of thinking and arrangement. It actually perpetuates, double victimization of women. So I have no difficulty about that. I would have voted differently on that. And I think if you look at the balance of the cases, we've not been that horrible, Sinamile. Think about our decision on Bear. On Bear, we said, no, you can't say only adult males inherit. What you're doing, actually, if you do that, you're going to make sure that women are perpetually dependent on men because they never get intergenerational wealth. They never inherit. In Shilobane, the question was asked, may a woman be a traditional leader? You know the answer. We said yes, by all means. There's no question about that. I've written judgments like, I think, Fanemeve on the common law and the way it protects a male partner from being sued by another partner And I said, no, women should be entitled to actually institute claims like that. Otherwise, they would be severely prejudiced. I've written another judgment on recognition of Indigenous marriages. And again, I said, no, the principle of equality ought to run right across. So I think the court has a pretty good record. In the book, I remember, I admit that I voted wrongly in Falks versus Robinson. And I say mea culpa, mea maxima culpa. So I made the wrong call and I went along with the majority of the judgment, okay? So I was nodding a bit and I say so in the book, that's not the decision I would have arrived at. So in my world, you go and look at my own liberator, my mother sits in the center. It's the centerpiece of my life. She was the one who stood up at the worst of times. When my dad cried, my mother was the one who said, no, it's not time for crying, it's time for fighting. So I hope the court will continue to protect and to advance and to acknowledge this inherent strength of women and their proper and respectable position at all times. I hope I've acquitted myself well, but there is record to show I've not been that chauvinistic after all.
Not at all, Judge Moseneke. I think that it's very comforting to hear that with retrospect, you perhaps would have taken another decision as a legal feminist and, or in the climate we're in right now with GBV. I think it's very important that you take that stance with women. So thank you so much.
Yes. Yes, indeed, we are duty bound to do that, Sinamile.
Okay, we can move on. Washington, you can take your conversation point, and then we can immediately move on to Vuyani and then Lisa. And then if we've got time, we can move back to the panelists, or otherwise if you want to, you can jump to your last session. But I'm not going to interrupt again. So Washington, you can go directly after this, and then Vuyani and then Lisa.
Okay, thank you so much, Prof. I'm so glad to be talking to you, Judge Moseneke. And after reading one of the last chapters in your book, I think the Flower Address, I felt as if you are leaving us to a place which will never reach you, or to a place where we'll never see you again. And it felt so real, as if you're going and you're gone. But I feel so honored to actually see you not in person, but through visual, and I'm glad for that. What I want to pose to you, Judge, it's an issue around the Judicial Service Commission and the judicial discipline, and it's something which you have noted in your book. And in your book, in All Rise, you've invited the reader to be the judge of the complainant of which is brought in front of the JSC regarding the issue of Judge President Lope, and regarding that whole issue. And I think today we've just got news that the JSC tribunal, which was supposed to be starting to happen today, is now postponed to December. And there are issues around that one of the advocates who are supposed to represent Judge President, which is Advocate Griffins, is also not there. So I think that whole issue now, it has brought an issue of, I think, us law students and also other citizens asking if it is a Judicial Service Commission hamstring on the structural or procedural impediments. Is it something structural, or it's something which is procedure, which is led to the delay? My first question. The second one regards to the judges. With this whole issue, can one say they're invincible? Because I would want to believe that if this whole issue was to say in courts of any standard citizen, where it has to go for 12 years, and when it has to come before the courts, it has to be postponed. And if the advocate is not there, then you go to court and say, my lawyer is not there, and then can we postpone? So can you say judges are invincible, or they are also still part of the citizens of the beautiful constructed constitution? And on a lighter note, thank you for the mention of the Russian dancer, and congratulations on the Sundowns winning. Thank you, Judge.
Well, I'll start with the easy part, the Sundowns part, yes. You know, you've got to choose your team, Washington. Each time you choose a team, you must just make sure it doesn't make you sad most of the time, right? The other day, I support Blue Bulls in rugby and they lost. So, every time I meet people, they say, Judge, you talked about Blue Bulls and Sundowns on television. Yes, but let me go on to say judges are not invincible. And judges should not be invincible and should never feel to be invincible. Remember that the whole structure and the architecture of the judiciary is one of high levels of accountability. Let me show to you. There's first professional accountability. If you write something and you are a magistrate, the judgment is an account to the people up here before you. You tell them how you've arrived at the decision. If they're unhappy, they have another chance at it and they go to the High Court. And one judge would sit there and that judge will check and see whether the magistrate has done the work properly. You saw it happen this morning. There's a certain gentleman called Azizi who appealed to the High Court on his bail. So our architecture assumes judicial fallibility. It assumes that judges will make errors, not the other way around. And that is why you always have the opportunity then to move to 3 judges in the High Court on appeal. And then you move to 5 judges, Supreme Court of Appeal. And you move to 11 judges, the Constitutional Court. And I explained that in the book for citizens to understand. But that is the professional side, the judicial function side. But then we have code of ethics and code of conduct for all judges. They're both global and domestic codes of ethics. And judges are supposed to behave in a particular way. Not because they're important, but because the job is done best when they behave in the way that is required. And if they don't, there must be consequences. Now in our country, excuse me, we established the Judicial Conduct, the JSC, Judicial Service Commission. It has a subcommittee which is supposed to be to deal with conduct of judges. And citizens are entitled to report under oath any judge who they believe has acted improperly or contrary to the ethical codes or judicial code. And then the JSC has to follow certain steps to make sure that the judge is tried fairly and there is a transparent outcome. Now in the book, I show you how we complained. I was one of the complainants. At the time when we had the tension in the country and Mr. Jacob Zuma had a case before the court about warrants of arrest at his home and warrants of searches rather. And one of the justices came to our court and tried to persuade other judges to behave in a particular way in their decisions and judgments. When we had that, we were not there, we complained about it and said, JSC, investigate this. 12 years, now in the book, I tell you carefully, step by step. We are now into our 13th year. And I'm one of the witnesses, so I won't go any further than that when Mutaringe. But I was also told that some advocate for Judge Strope will not be available. Now, this date was set 6 months ago. So it should have, if it wasn't available 6 months ago, then it should have been set, a different date should have been set, maybe earlier when it's available. So yes, it will be postponed again. Is this a structural or procedural problem? Both. The JSC is supposed to do certain things quickly and fast and has not done so. And so that has taken a lot of time. And it points to whether judges are conscious of their duty to submit to the discipline of their profession. I think every judge should make himself available. Judges know a lot about procedural rings. They can run rings around the process because they are the masters of process. They manage and regulate process. So a judge could send you down the line, as you have seen here, for 12 years. So there are procedural difficulties, and usually it's judges who stop it. This is your final postponement. We say often in court, next time you appear here, the case continues, with or without your counsel. You must have heard that. It's when judges believe that there's been procedural misusage. We haven't had it here, and we should have it here. And I write it in the book to talk about judicial accountability. And that judges themselves should be subjected to all of that. And the people should be entitled to say, no, we don't like what we see. So there's no inherent protection only because you're a judge to give you the answer. Judges are not invincible. Thanks.
Dumela Ntate Dikgang.
Hey, Riani Dumela.
So my question
Really,
yes, definitely Diateta.
of course, it is fine. The all African languages, you should be able to master most of them, if not all of them.
I tried. I tried. So my question relates to how you started the book when you were describing the precision of common law and its history and customary law. And you mentioned that the common law is imported law, was common to all the inhabitants in the country, including those who were considered to be, who could not vote or considered as not citizens in the country at the time, right? And my question is that at the advent of constitutional democracy, seemingly restored customary law as one of the sources of South African law. However, when one reads section 8.3, read with section 8.2, there's in terms of direct horizontal application of the Bill of Rights, there's no mention of customary law in terms of which one can it can give effect to constitutional rights. Right? Does this mean that customary law is unable to give effect to constitutional rights? And when will it find its place in the South African landscape? I'm just really thinking about what you wrote in Gomede, which is a standing judgment, where you said that the adaptation of customary law serves a number of important constitutional purposes. First, this purpose would ensure that customary law, like statutory law, common law, is brought into harmony with our supreme law and its values and brought in line with international standards. Therefore, it bears repetition with the petition that it is a legitimate object to have a flourishing, constitutionally compliant customary law that lives side by side with common law and legislation. So I really want to know in relation to the development of customary law, one read it as what Nate Nkasaka wrote, that in relation to belonging and citizenship, that it is considered as native of nowhere, a stateless person or a permanent wanderer. So I really want to hear your views on that.
Vianney, it's a very complicated question you've asked. And it's complicated because it really does raise quite fundamental questions about belonging, about trying to reclaim what essentially has been rendered a poor cousin in legal sources. In the book, I start by trying to explain to you, particularly to you young people, why and how that happened. If you are conquered, conquest comes with a number of things. One of those is you lose the land. Another is that you lose the use of the law that you have used up to that point. And then an imposition occurs. In other words, both language and law gets imposed. And that's what the first chapter of the book is about. It tells you, hey, I'm a lawyer, but look at the hoops I had to go through to get to where I am. And the reason was that. Now and of course, over that 350 years or so up to 1990, what do you think happened up to 1994? Customary law was denigrated. And in the book, I give you examples of how our marriages never made, master. They were not marriages at all. And how marriages by Muslim rights are not marriages. Go and read what I wrote in the Campbell judgment. And I'm so delighted that you quoted Gumede, and you know where my heart sits. Our challenge, therefore, in 1994. Now, in 1994, when we debated the new constitution, the question was, what do we do with inherited law? And the two mainstreams of inherited law were common law and indigenous law. You tick the one box we said would preserve both laws. And as a practical decision besides anything else, you could wake up one morning and so many areas of law are not regulated. That would affect marriages, that would affect both indigenous and and common law marriages and so on and so on. It affected so many things. So the option was to preserve all existing law and to subject it to the supremacy of the Constitution. Now, the laws were unequal for the reasons I told you of imposition, unequal in observance. And in fact, your law schools taught you common law all the time and indigenous law as a sidekick. But it's another reason. Socioeconomic circumstances moved on, Vuyani. More and more people became urbanized. And there are certain things that never changed. For instance, the way African people married is beautiful. It's a liaison between two families. And that whole procedure and arrangement around Bokhadi or Lobolo, it's just so wonderful. As you know, I know it's not about Inkomo, it's about how to build a joint liaison between two families. And I'm to introduce the families to each other and to build bonds that last long, like mine. I've been married to my wife for 44 years. So I have another family in her family, okay? So what am I saying? I'm saying the valuable things. For instance, collectivism, notions of human solidarity that you find in Ubuntu. It's valuable value system there. An indigenous, African indigenous education system, knowledge systems. But we have not and will have to do more. I often get asked in other webinars, what should law schools do? What does decolonizing the curriculum mean? It's a preparedness and readiness, one, to acknowledge that common law was an imposition. Two, to say that it has become part of our law, and we have acknowledged that in 1994. Three, that it must, however, adapt in a way that the Constitution. And you are correct to say section 8.3, 8.2, and 8.3 do not mention indigenous law by name. And I think it's a horrific omission. You should not have that kind of omission because the two are normally mentioned within the same breath. But you know that when the transition, if you go and look at the book, the tension that existed between those adherents of the common law, I write about that in the book, and the new constitutionalists like me who insisted that the starting point and the source, origo et fons of the law is the Constitution. And it is a Constitution which contains the most recent common values that we've reduced to writing. So you can't insist that the proper values are those of 16th century in Holland, which are the roots of the common law, or 16th century England, for that matter. That's where our commercial law mainly derives. So there is a task, just as much as we did what we did to try and transform and change the judiciary, the academy, together with the judges, of course, have that obligation to reshape the law as we move on, as we try to do in Gumede, for instance. We try to do in Bear, but we've tried to do in other cases where we have adapted the common law to make it more responsive to our understanding, because its origins were really feudal. And then apartheid, of course, was imposed over the common law, which made it quite a difficult and repressive system. So having said all that, we therefore have to, you young guns, have to go out there. We've tried. We've written about Ubuntu in our judgments. We've complained about how, for instance, the Zulu code, it's a patriarchal horror. The man sits at the top of everything else, and everything else revolves around him, maybe with 7, 8, 10 wives and children, and all the property is held in a particular way, and women have no opportunity. And the traditional African society, you know, is not like that. Omama are much more powerful in that society than the code reflects. So there's a lot of work to be done, in short. We have to integrate, but not all values of Indigenous law are available. Patriarchy is not available. Our land tenure system, where women are not able to hold property in their own right, that's not always helpful. It leads to deepened poverty. And if you leave all the land in the hands of the chief only, or the traditional leader, then it makes Omame to be more subservient. So it's not everything that's good that has come with the common law, nor is everything that's good that has come with Indigenous law. The challenge is to modernize both so that they must answer to our needs. And lastly, somebody asked me in a webinar, the University of the Free State, how dare you give damages under the Constitution? The notion being damages are granted only under the common law. It's a very high level of arrogance there, isn't there? You cannot say that it doesn't matter how egregious the breaches are of the Constitution. In a delictual sense, there can't be any damages that would follow. If you do that, you actually emasculate the Constitution. You're really saying there can't be any remedy out of the Constitution in a private law sense. And you must all go through the common law. I mean, it's a self-serving argument that is unhelpful. So we must be alive to that, and the academy must be made more aware and alive to the fact that we ought to adapt and free our law from preconceptions of the past. It's a long answer, Biani, sorry, but I'm sure you've heard every word I dropped. I meant it, and I was trying to answer your conundrum.
I certainly did. And you raised an important part of common law damages, and this was reflected in the Life is a Demeni matter, and where they had to come, where it was awarded constitutional common law damages were awarded to the people. So my question would, I don't know, how would have customary law damages would have looked like in that case? I'm just thinking that one of the panelists and I were talking about life in Sidimeni, and the meaning of Sidimeni means dignity, and how the patients were not given Isidima at all, and there were no any punitive measures for those people who did harm to those folks. I'm really thinking about what a person says in his clause of Molo Unjani or Sawubona in Sizulu. It's somehow the social contract that acknowledge that I will not harm you in some instance. And what they just simply got an award, simply got money and a public apology. That something does not sit well with me in that regard.
Yeah. Of course, we can debate about what else should have included, but it's probably one of the most progressive judgments on the subject currently. The state was required to apologize, which they did. You formulate damages usually sounding in money. You could make it in other ways, even in indigenous law, Yashaula Anditi, right? You pay damages. They would have sounded in heads of cattle or something, but you do if something wrong has been done like that. The big point about, of course, Esidimeni was a flagrant violation of the dignity of the people. So we accept that. There's no, and we say that in so many words in the order, in the award. For me, the key fundamental question was, the government argued that you must give damages under the common law. And if you do, the examples of common law are limited to psychological harm and to injuria, to personality rights in their limited form, as you find the common law. But the broader question was, where state violates just about every constitutional precept, where do you draw the authority to grant damages? In the common law? But was developed in the 16th century. There were no constitutional entitlements like the one you find today in the Constitution. So it is inadequate in every way for the task at hand. And that's the point I was trying to make. So the damages were not common law damages, they were constitutional damages. And if we're serious about changing our law, then we need to give strength and power to the Constitution. As you know, I'm not wedded to it, it can be changed and it should be changed. I wrote a published article where I tell you all the defects in the Constitution. So I know it is an imperfect document in many, many ways. But that doesn't mean we don't have to observe what we have, otherwise we've got a chaotic society. Thanks.
Good afternoon, Judge Moseneke.
Good afternoon, Lisa.
So I have 2 points to make, and hopefully we have enough time. The first point was that when reading All Rise, I noticed that the Chaskelson Court was marked by a highly transformative character, and the leadership really propelled the transformative project and laid down a foundation for the rise of a constitutional jurisprudence. We also get the idea that the transformative project was a joint effort between organs of state based on the good relationship between the judiciary and the executive that you talk about in chapter 14. However, when we move away from the Chaskelson Court, we also see that that relationship between the two branches is severed, and the transformative focus sort of loses traction. Do you think that the constitutional promise or dream has been blurred along the way as a result of the political turmoil in our country? And what would you suggest we do to realign ourselves with this, with our constitutional dream? And the second point I wanted to make was that towards the end of the book, and particularly in chapter 5, you speak of the funny charge made by some members of the executive that we live in a judeocracy. And you succinctly debunk this claim. And I must say that I do agree with the points that you make. However, I find it hard to wrap my head around the view that the judiciary encroaches on the functions of other organs of state, especially when members of the political elite, as you have termed them, have a tendency of failing to implement court orders. For instance, we know of Mrs. Grootboom, who died without a house, even after her name has been used in one of the most important judgments in our country. And also the odd 100 victims of the Estimeni tragedy that still have not been compensated. So then the question for me that arises is whether court orders and even orders from the apex court itself make a difference for ordinary citizens who are reliant on the courts to compel the state to make good on its constitutional obligations and promises.
Well, excuse me, Lisa, thank you for that. I said to somebody the other day that one of the biggest rewards of a writer is to run into somebody who has actually read the words that you've written down. That's the reward, because then it makes the task worth one's while, that somebody like Lisa would go out there and work it out. Yes, you're right. The Chaskilson court was a honeymoon court, as I call it. And everything was honeymoon behind us, if you remember, just a minute after 1994. And I go out of the courtroom to show you how we won sort of the Rugby Cup, how we got out to win, Bafana went to win Africa Cup of Nations, and how everything seems okay. Penny Haynes was winning golds, and Tugwani was winning marathons at Olympics. It was all fine. It looked like our world was going to start again, afresh. And it is there where I recall Utatu Umatiba's inauguration speech, where he said, "Let freedom reign." An achievement, may the sun never set on an achievement so glorious. That is there, you remember, where he said, "Let there be bread, let there be salt, let there be water, let there be life for the people." So in other words, it was that moment where we had an opportunity to be able to go somewhere, and the court finds that space to be transformative. And the stability in the background politically. But then the court had an avalanche of cases where people have suddenly become free, were asserting every conceivable right, starting with one against Mr. Mandela himself, you remember, in Hugo versus the President of the Republic, where he granted prison pardon to women only, on the grounds that women are, the ones who look after children. And Mr. Hugo came and said, "Nonsense, I'm a father, unmarried, and I have children. Why exclude me from the prison pardon?" So Hugo is a very interesting case where Mr. Mandela showed his patriarchal tendencies quite early by pardoning omama, because they are the ones who nega ojonga abantwana ekhaya. And somebody called him out and said, no, I'm a father and I look after my children, sorry. So, and the court came out and said, "I win, you can't do that." So, but it was still light until we ran into TAC, I show you in the book. And once we got into AC, there was now the contestation was starting between the judiciary really a judiciary that was prepared to assert those rights. And then follows all of those cases, Casey and Grootboom and name it, all of them start flowing from that point. So we have a very admirable rights jurisprudence. And you're right, it was mainly through the Chaskalson court, but it also came through far less in other courts. But comes Pius Langa and Dikgang Moseneke as chief and deputy chief, hell breaks loose in Polokwane, right? And there's a park contestation. It lives up to this day, right? You need to pick up your newspaper, you'll know, or whatever, your social media and so on, you know that. And once that rift happened, that contestation was formulated in legal terms. And I show you through the book, as you have seen, Lisa, how the transformative project gets pushed aside as we really start battling the parameters of executive power, legislative power. Now we're battling tenders. Have the tenders been issued in accordance with the Constitution? Those were early days, but there they were, these cases were coming through. Cases like Steenkamp, cases like were starting to come through until Gqeberha Sasa, which was a big one. And now we know just how many hundreds of millions were stolen from Sasa, you know, before it even reached the people. So yes, when we were in charge as Deputy Chief Justice, and from Shabir Sheikh's conviction, from then on, the fight was fully on and fully blown. And the transformative project took the background, but other things happened, as you know, Lisa. There was pillaring of the judiciary. And some of them must be spies and sellouts and what else, you know, and are supposed to be this good young Africanist, Pan-Africanist man who has done all his life fighting for land and freedom, and our people suddenly was a sellout who was trying to derail, when in fact, I was basically saying no. And that's why I said to Mr. Zuma, well, you must prove it. And in the book, I tell you the tale of how I said, you go and find the evidence. And of course, National Intelligence came back and said, no, Moseneke is a great patriot. He's a real son of the soil. Siamtanda. There's no such thing, you know? Because I too, like Justice Van Westhuizen, I was saying, just show me the account so that I can get the dollars, you know, which were paid by the CIA. Because I'm a civil servant. Anyway, but on a more serious note, yes, then we had a slippery slope. And part of the charge was, this is a judeocracy. We are ruled by judges up. And we have to follow. And I tell you the little story of Mr. Jacob Zuma, telling me about his discussion with brother leader Gaddafi about the place and role of judges and whether they are the ones who are ruling the country. The answer is no. Judges have neither the sword nor the purse, as you know. Judges survive on moral suasion. They make orders which the state is obliged to implement. And we know that they have not always implemented some of the important orders, which is your point. And therefore, that time was very counterproductive because it actually kept on giving rise to the notion that there is some justification for ignoring the courts, but there was actually none. The political elite was seeking to resist living within the ambit of the law. And they have the power to change the law. They're the majority in parliament. They could do with the law what they wanted to, provided it was constitutional. So there was really, it was an unfortunate 10 years of, and I think it's continuing in it, but at a much lower level of contestation now. And as the political fights increase, you're going to see the courts being the terrain of struggle, whether it is through the public protector or through other players coming to the courts. And there'll be a debate about whether the judiciary is captured or not. But for now, I think judges have been very conscious of trying to keep within the limits of their power. Thanks.
Okay, good afternoon, everyone. I see our Dean, Professor Lawrence Juma, has joined us. So welcome, Lawrence. It's nice to have you here as well. We are running slightly over time, but I do think it's important. So at this stage, I would like all four our panelists, as well as Judge Moseneke, to let's give it 10 minutes or so for our last topic on barriers and opportunities, where to for South African constitutional democracy. So at this stage, let's put aside about 10 minutes or so, and after that, I'll hand over to Professor Kruger for a short question and answer session where you are welcome to ask questions and pose questions. Judge Moseneke. So please feel free in any order that you want to pose a question. Whoever wants to answer the question, feel free to do so. And I ask all our panelists to join us now and to kick off the conversation.
I think I'll go first. Justice Moseneke, in the book, you kind of detail the barriers to entry in terms of when you were in Robben Island and studying for your law degree. You speak about the language barriers, the economic barriers, and all the very much adverse circumstances you were in getting your law degree. Some of those difficult circumstances still exist for students today, in particular issues with class and maybe a language barrier. How do we move forward from your time, you experiencing those hardships to now? How does one stay motivated despite or in spite of the constitutional promise?
Yes, I want to be brief in these answers, unlike the previous ones, but yes, you know, I would hope the barriers are not structural. If they're structural, we have to make sure that they are removed. For instance, in that sense, the fees must fall movement is a very vital, important one. Because it really is, as you know, I've always supported that access to free education. We can debate the definitions. What is access, what is free? But the principle remains quite clear that after long spells of oppression, there are few things that actually help to level the playing fields as education itself. So if there are structural barriers to education, then it's a double whammy. You can't get in, and even after getting in, then you're going to have other barriers, access to the profession itself and to a more just society. So whatever we do, we must make sure that there are no barriers to access the profession. I've said out mine, but they're historical. And I don't want any of you to stand back and say it is not worth our while. It is worth our while. And I hope my story, my little tale of this township boy from Oxfordville in Tshwane to now speaks to what is possible. So we have to look out for structure, and the academy and all those, all of you who are activists who sit on student law society council, law council, and whatever else, you must keep your eyes peeled wide to ensure that as many people come in. And law profession is now, we know, useful far more than just practicing law. And I want to see all those young, professionals coming out of university, graduates, getting out to go and try and make society better. So yes, we should fight those, and we should make sure that they're not structural, and if they are, we should agitate for those to be got out of the way. But despite the difficult situation, the world is your oyster. So I dedicated the book to you, and just make sure. You see why? Political elite come and go. They're never there forever. Some that you can almost, whether you look at Mali, or you look at Belarus, or you look at Sudan, or you look at the US, or you can look at the world around, political elite. Look at Thailand. The young people woke up and said, we don't want a king. We don't want a monarchy. What for? Or Hong Kong, or so. They're never there forever. But you will be here for a long time because you're young. And you've got to formulate your generational mission. Thanks.
Okay. I think for me, Judge Moseneke, the question which I would have is, since in your long career, you have worked with different candidates which have come from law schools, and my question to you would be on what do you think our law schools, institutions should do maybe to make or breed better lawyers and to go further, better judges in terms of not only teaching the history of the law, but also nurturing the character of a lawyer, or of a lawyer who is also still a citizen who can have a part to impact on the society as a whole. Like, what is it that is there or which was lacking, which can
Yes, Washington, thank you. I mean, the answer is in the question. It's a brilliant question. I, and a few other webinars I did, I spent more time talking about the academy and what ought, and the debate that should be had about what should be the character of the lawyer that comes out of law school. Given our history up to now, now remember, or let's see, what is a lawyer? A lawyer is somebody who is trained in the law of the country and who then gets trained on how to apply the law. And thirdly, who gets out there to use those skills in order to make a difference in society. In other words, to help create a just society, particularly given our own history. So law schools, as I said to you, they should understand their transformative role as a law school. And one of these is to make more central ethical questions that come out of legal leadership, judicial leadership, or participation. Those should take a fairly big front part. And those include dedication to the client, to the people. Lawyers and judges must have a deep sense of fairness. And they must commit to the broader, you're right, project of a country to become just and fair. And we've had terrible aberrations in the past 10 years where so many lawyers were found with their hands in the cookie jar. But not only that, so many accountants and auditors who went along with earning big monies and amounts and forgot their ethical positions. You know how many of them had to be charged or return money, and auditors are supposed to be big guardians, so too lawyers, guardians of society. So we have to, because of our history now, make sure that we teach the law, and must be a law that gets us to a just society. And you're right, not only for its historical significance, but also from its present day significance. And there must be people who can go out there and go and say, oh yeah, I'll be part of Education for All tomorrow. I want to know what are those things that are not equal in the education setting, and how best can we make them equal. I want to go out there and do mainly housing, or to join Section 27, access to healthcare. And it doesn't have to be those organizations. You can form others. You can start projects around those things. So this is the time when lawyers should be really in the forefront. Think about civil accountability. Lawyers should be upfront there. Think about political accountability. training people about the right to vote, their political rights, which are set out in the Constitution and so on. All that is very vital. Thanks.
Judge, I have just one point to make. As you have said earlier, that the title of the book is instructive and commands that we exercise our agency as citizens and to hold our leaders accountable. Would you not say, though, that the youth has heeded the call and risen by taking to the streets in protest to express our discontent and our views on social issues that plague our society? I mean, if you consider, for example, movements such as Rhodes Must Fall, Fees Must Fall, as you have mentioned, RU reference list, and so on and so forth. And do you perhaps have any suggestions on how we can rise effectively?
Lisa, thanks. No, I'm not going to give any suggestions, Lisa. You are right that students have been up from there, and they've demonstrated agency, both individual and collective. And that is what I call for and pray for in this book and in my own Liberator. And that is why even in that time I supported the notion that there should be adequate access to education and higher education, and that the state should pay for it. And I was not far off the mark given the amount of money that was otherwise abused and used and taken away by a few greedy executives who are close to the till. So you must stay right there, you must stay on your post, Lisa. You must proceed to press for accountability. And as I say, I hope you will not sit in a corner and, your little corner and eat your pie and say, what shall we do? No, there are things that you can do. But formulating the generational mission is your job. I formulated my generational mission, which was to overthrow and destroy apartheid. Disappointed as I am that we haven't done most of the things we had hoped to do. We've done others. Just the fact that you guys are here and are debating with me and are at university, it shows that we have done some progress, not nearly enough. So I hope you all stick in there and slum it out and be ready to be active citizens. The day all of you go to slum when you are young, we did. Because in any society, it's the young people who set the tone. They did it in my generation, they did it in 1976. They did it in the 1980s. They did it with Fees Must Fall. It's young people who often discover the irritants in society. The one proviso, as I've always said, it must be peaceful. We can't destroy our own institutions. And now that I'm an alumnus of Rhodes, I don't want to see Rhodes destroyed at all. It's an important place where we should produce all of you, and we do not disrupt in ways that we cannot deliver education. It's going to be very important. So we have to do it within limits that allow us to keep these valuable institutions, and we turn them into instruments for change and not for retrogression. Thanks.
I wanted to ask, what would you say to a final year student who's incredibly anxious during this time? They're ending their degree and they know employment prospects. And they're probably thinking of leaving, going to teach English in China because they're tired of fighting. They've been involved in Fees Must Fall, and they are just scared of state-sanctioned violence against them if they do take it to the streets. So what would you say to those young Dikgang who are coming, who don't sleep at night, who are worried?
Yeah. Yes, and I take it fully, I take it in fully. It is a serious change. Part of it is because we messed around with an opportunity to create a much more vibrant economy. the more vibrant, the bigger, and the functional the economy, inclusive economy, the more Vuyani and others and new Dikgangs will find space. And it shouldn't happen by way of exceptionalism, but it should happen as predominant norm that young people will find an opportunity. I've said more lately that one, there should always be an attempt by a small class of law graduates to get into practice, difficult as it is. There'll be another small layer and lever who hopefully would go to the court where I worked for 15 years and go and clerk there and learn new skills and values. Most of the clerks who have come out of our courts have gone out to go and work at a number of civil society entities, and they're making a difference. And I hope, therefore, three, there will be a layer of young graduates who would go out and try and seek civil society entities who would remain critical, observant, would measure what is done and what is not done, and who would make it known and be out there and ensure that they keep accountable those who've got to do it. Four, I would hope that many of the graduates that are to come out in the next good few years will become public servants. They must give up the notion of shiny cars and Armani suits from the get-go and embrace the notion that they should become prosecutors, should become state advocates. They should work in the state law advisory office. They should work for the public protector. They should work at Treasury. They should, now if I start to go, some should go and work at forensic laboratories in our country. Some should join the police force. Somebody was saying the other day that there are not nearly enough people who are qualified in law and in finances and accounts and auditing within the Scorpions and SIU and so on. I'm not saying as fact, I saw it in an article. So the best of our brains should be going that direction. I saw the NPA, there's an article that they have, I don't know how many vacant posts in the NPA. But if you go around in all of those entities, you need young people who want to insist on accountability, who will act only lawfully, and who would refuse to do the bidding of a political elite who tell them to sign here so that imali iphumele kwenye icala. So you guys may have to go and guard the transformation of your land by your very bodies, yourselves. We had to get into practice because we were not part of the government. We had no chance to be part. And when it was possible, me and many other judges you see today, excuse me, look how transformed is the judiciary and the magistracy as a whole. If you look at your television, you'll see who the judges are, who the magistrates are. And it is necessary that we go and get diligent prosecutors. Some people, LLBs, should go and join the police force because we must strengthen those upper echelons of those bodies and refuse to act unlawfully or to act only on the direction of the political elite. So that is my advice, Vuyani, is I hope nobody leaves the country. And I hope some will become entrepreneurs, and we actually have to rise ourselves. But I hope many, many others will take instruments of state and make them to serve the people, as some of us tried in the judiciary. And there are many places where you could get that job. Just forget about the early Ferrari and the Armani suits and go and work within the public space. Thanks.
Thank you very much, Judge Moseneke. I hope our student attendees this afternoon has taken note of specifically that last comment there. And to our 4 panelists, our prospective graduates and our prospective NPA employees and maybe also, as Judge Moseneke said, public servants. Thank you very much for taking part. I'm going to give over to Professor Kruger now for a short question and answer session, after which we will close the webinar and say our last thanks. Roseanne, thanks.
Good afternoon. Thank you very much. I invite attendees to use the Q&A button at the bottom of the screen to add questions that you may wish to ask, so that I could relay those to Judge Moseneke. I've received one question that I can put forth, but I think I will abuse my opportunity here to you refer to the opportunity that exists in relation to Washington's question about judicial discipline and the ways in which we can deal with issues of judicial discipline. And particularly you spoke about the hierarchy of courts through which we can correct incorrect decisions from lower courts. What do we do about incredibly expensive, not inexpensive, incredibly high legal fees and that the hampering that places on the ordinary person to pursue, for example, justice in the Constitutional Court?
Yes, totally valid point. And I mean, and that's part of the civil accountability, and I hope will begin to kick in, Professor Kriel, which is really young people flowing into the bar and refusing to charge those mad fees. That might be part of their civil, I want to call it resistance, but consciousness. You know, it can be changed. Of course, when I remember I spent time, remember in the book somewhere where I talk about the bar rules that you must charge a fee, and you must charge a fee within a certain range and parameter. And you may not undercut your colleagues. It's a closed shop arrangement. And how in doing political trials, I always said the challenge that those I was defending had no money and the attorneys had no money. I used to come out in Gramstad and other places to come and do terrorism and all other public violence trials, but the people did not have money. So if you charge the rates that the Bar Council had set, which were inspired by commercial rates, because those said the Bar Council were really acting for large corporations, you will never give service. So young advocates and attorneys should be taking whatever the client can give, and should be increasingly accepting a much more modest lifestyle. You heard me talk about that. Away from the cult that the ruling elite has introduced of Ferraris, etc., 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 and more Chandon and all of that crazy lifestyle that in itself fuels the need for more money and fuels, therefore, indiscretions, financial indiscretions, and suddenly the whole society, I would like to see most of them become academics. Well, become your sidekicks, and we shouldn't talk about a transformed or untransformed academy when there are no people flowing into the academy who are prepared to dedicate their lives to the modest salaries that, you know, people in the academy earn. So that is my answer really is, I hope the young people will get it and will go out there and stop. And I've been saying and preaching about it. Stop the exorbitant amounts in favor of more modest amounts, as long as they can pay the rent and wash their face and drive a small little buggy, then that's fine.
Absolutely. I absolutely agree with you. With more people joining the academy, we desperately need fresh ideas to invigorate our conversations about constitutional democracy, most certainly. And here I have a question from Chris Matthews, who's a first-year student. And he asks the following: do the recent increase in arbitration proceedings leave you with any worries about the competency of the judiciary moving forward? If so, what advice would you give to young South Africans wishing to positively influence or make a difference in the judiciary?
Yes, Chris Matthews, again, almost the same answer. Yes, I mean, what is happening is a certain level of privatization of the judicial function. By that I mean, those who have money don't want to go and wait for 2 years, waiting lists in the civil courts. And they find smart retired judges and say to them, would you decide this matter for me?
Mm.
And that is happening, and they pick them carefully and say, in the system, you can't choose your judge because you're given a judge. In arbitration, you can pick your judge, provided both parties agree. Both must agree that that is the right judge. So yes, arbitration is a valuable thing, but of course, its side effect is that you're taking away some of the disputes that might help to formulate the law and channel them into arbitrations. So we need to make the court system more efficient. We need to try and have a throughput that is faster and more effective. And as you see in the book, Chris, I complain about the perennial shortage of judges. Judges work so hard because the way our original system was styled to serve 2-3 million people under apartheid. And 1994 came and suddenly there were 54 million people.
True. Yeah.
So our universities too, we built new universities, barring 1 or 2 there. So they were always meant for a smaller population. And suddenly we had this large democratic pool from which we could draw. So I hope, yes, courts should get more efficient and younger people should get in there and work harder for less money, but more quality.
From Paulina Nkosi, who says, it's clear from Life Isidimeni that government has little regard for court orders. And in addition to that, separation of powers also limits the power of the court to legislate, so to speak. The question then becomes, what do ordinary people do? Or what resort do we foresee that ordinary people may have?
Yes, I just want to say very quickly, I'm going to answer the question, the rump of the question. In Life Isidimeni, the people were originally before me were all paid.
Yes, yes.
They were all paid.
Yes.
What remained, and a lot of new people
came forward.
In other words, who were not before the courts at the time of the hearing. I just want to correct that impression. It's not the province was quite good in paying everybody who was before me. But even in the order, I say that there are many people on before me, and it was true. Not all could be there in time, and that they will come. So those are coming up, and there are all sorts of hoops and challenges about whether they truly qualify to be compensated or not. So I don't want to be unfair to the government, to the province in particular, who have played along in Life Isidimeni. But yes, there are instances where court orders are not respected. And if they are not respected by lip service, we're going to do it, and it's not quite get done, and so on and so on. But then comes the accountability question, which I have raised in other seminars. You see, the highest form of accountability in a democracy is political accountability.
Absolutely.
Civil accountability is interim, in between the big push for who gets given the authority to exercise public power. Much as elections are important, or civil accountability is important, much as people should be out there with placards and say, I don't like this, much as people should be writing petitions and articles, much as they should be moving social media, and most politicians know and look and see, they can see what people don't like. That's always helpful. They don't always respond, they're not always responsive. The Constitution requires them to be, but not always. I mean, take something like in Belarus. I know they have responsiveness as one of the principles, one of the new democracies. But the rulers there are not exactly listening to what the people are saying. This is an example. So we've seen the response of government in Nigeria recently, in protests in the streets in public. But the people must know and remember that the highest form of accountability is political accountability. And also remember that democracy is premised on insecurity of tenure. If you know you'll always be in office, you don't have to listen to anybody, frankly.
True.
If there is a real risk that you might not be in office, then you listen to those who give you, who confer to you the public power. So just remember that. That is my answer to you. The highest form of accountability is public accountability, is political accountability. You have to choose who you give the power to. Thanks.
Judge, then I have a question here from a colleague of mine, Helen Cruz. She says, you suggest that legal practitioners should serve the client and society, but often the client and society's interests conflict. What is the practitioner to do in that instance?
Yes. We'll have to unpack a little more there. I'm not sure how these would conflict. If it's about the law, of course, you must display fidelity to the law all the time. If by society, you mean decisions that society has made through law.
I would
imagine. Has been formulated.
Sorry, I would imagine it would mean that the public good would not necessarily be served if the client's interests are served.
Yes, I mean, generally, that's how it would work. The two should be aligned. Generally, I mean, I understand if somebody is charged in a criminal court, the inclination would be that they should be freed without consequences. If that's what you mean, that's not going to happen. I mean, the law is going to take its course and justice has to be served. And part of it might be punishment, might be held liable for damages. And that's what the law is there for, to enforce civil or criminal accountability. But generally, when you practitioners serve a client well, you're generally adding to social good. And if there's conflict, of course, you've got to weigh it quite carefully, but always weigh in favor of a lawful response and a just response.
Judge, I'm just reminded, and I've discussed this issue with my colleague before. Say, for example, where a claim has prescribed, but prescription needs to be specifically pleaded. And yes. if it is not, and if it is of such the claim is of such a nature that it would be against the greater public good if the claim of prescription is then pleaded, and so the practitioners between a rock and a hard place. On the one hand, there's the duty to client, and then on the other hand, there's this important, bigger societal justice, rather, that one would have to consider. So I think that was pretty much the context within which the question was. I don't refer to criminal matters, but the ability of legal practitioners to evade accountability for their clients in tender fraud. And the Njongi case is mentioned as an example.
Yes, of course, you know, when that conflict comes, it's always going to be a difficult one, I think. At best of times, clients' interests and those of the larger society should be aligned. Prescription, for instance, much as it might impede an individual case, it's important for legal certainty.
Yes.
It doesn't permit people to play around with their claims over a long time and not do them timeously. So it's a tool of the law to encourage timeousness and efficiency. So when it is properly pleaded and it succeeds, the client loses, but the broader community society wins, I think. Those are simple examples. I mean, they're more, Njongi was very, very complicated.
Yes, yes. No, Njongi was particularly complicated.
Real tension, just complicated. And I was still on the court and I remember something about it.
I then have a last question, and if there are any of the other attendees, because we have eaten into Judge Moseneke's afternoon in the most serious way. So if you would like to type your question in the next minute or two, I can find the last question. I've got one more question here, but I received a question much earlier from Dooms. First of all, thanking you for your patriotic service to South Africa, and then asked whether there should be a policy governing succession when it comes to a Deputy Chief Justice and a Chief Justice. In your view, should there be a way in which that is regulated in terms of policy rather than being left to the choice of the president?
Yes, an interesting question, and it's a big policy question. The Indian Supreme Court, faced with the vagaries of political preference, caused the matter to be argued before it to settle the question rather than wait for the legislature. I'm not suggesting that we should do that. And the reason was this, that the political elite would look around amongst the justices of the Indian Supreme Court and handpick the one they like and say, you're the new boss. And they sometimes would whisper into his ear, Ellie. And that makes the court quite divided, because this person is now hoping to become the new Chief Justice and starts, you know, in some ways might behave in ways that are unacceptable. And they were fed up of that, and then they decided to hear a matter, and they ruled that it would be unconstitutional to exercise political preference in determining the head of the Supreme Court, and that it will happen by strict succession. That's more stable, that is predictable, that is fairer. And for that reason, the last well-known Chief Justice of India was Chief Justice Bhangwati, because the rest would be in there only for 2 years, because they're coming at the end of their careers.
Yeah.
So it doesn't become a big hoo-ha and fight and brouhaha about who becomes a chief or who becomes a deputy. I'm just giving that example just to look outside our borders. We made a different choice. Our choice was all the other judges are really appointed by the JSC. Once you have passed the JSC process, the president may not keep you out. Because it's this representative body, as you know, the academy is represented there, judges are represented, attorneys are represented. So it's a much broader body. You'll have to have a big conspiracy to actually bribe many people to get somebody go past the JSC. And lastly, the public has the right to come in and say, oh, I know her. She once stole chicken at Pick and Pay. Don't allow her to be a judge, okay? So it is quite transparent, it's open, it's very rare in the world actually. Our system is quite quite. So it limits political choice. So the president can't refuse to appoint somebody once the JSC has recommended that person. And if the president refuses, the constitution says he must set out the whole thesis why he wouldn't or she wouldn't appoint that person. It has never happened up to now. So that part we've taken care of. And the president can't go ahead and pick whoever he likes in the street and say, you're going to be my new judge. So he can't pack the court, in short. So we've done well at that level. The Constitution makes an exception, as you know, and I described this in the book in some detail, with the Chief Justice, Deputy Chief Justice, and the head of the Supreme Court of Appeals. The provisions in that regard are that the president moves first. She makes the first move. I want to appoint Dikgang Moseneke as the Chief Justice. Or as he did, he always made a move to appoint anybody other than the one who bears the name Moseneke. Okay, so 3 times he did that and understand that. Now, for now, the prerogative is his, as the Constitution stands. The question is, should we change that? I think that is the question. The reasoning in 1994 was that it was a good check and balance kind of arrangement between the judiciary and the executive. The judiciary mustn't choose its own leader, so to speak, and gives the other arms of the state an opportunity to have influence over the judiciary. So I'm not too hot on that, but I do see that there are now jockeying positions and people are beginning to write articles. People are beginning to say, no, it must be a woman. Somebody will say, no, it must be a tall, dark man like Moseneke, and somebody might say, and so it might go, you know what I mean? So we have to be careful how far and down the line we go. I'm very uncertain, and I don't want to say to change only because I got the bad end of that system. But I think our president should really act in good faith, apply her mind properly. And I've said before, if it is a woman who will be appointed or a man, each must fit the bill, must have the characteristics that are good for a Chief Justice. I don't care too much how they look. I do care how they think, their commitment to the Constitution, their commitment and faithfulness to the interest of the broader society in an inclusive way and diverse way. All the values that we think are valuable and important for our country, and not to pander to the political elite, for instance. That is my mantra, as you know. You do what the Constitution and the law wants, not what the political leaders want. So I hope it will be a Chief Justice like that. Whether we change the rule, we must debate that further. I'm not certain.
Okay, I have got a couple more questions. With your permission, Judge, I'm going to finish because they are fairly diverse. 2 of the questions I think I can put together, and then the other 2 questions I will put, so 3 questions in total, and then I think you definitely are entitled to your cup of tea with Mrs. Moseneke, and thank you for your time. But okay, so Chris Gogodla asks, Chris Gogodla asks, the question relates to the concept of Ubuntu. How best can Ubuntu be incorporated into judgments without compromising the application of law? Chris's words.
Well, how do we incorporate the value of dignity without compromising application of the law? You see, Chris, there are lawyers who are called black letter lawyers. They believe all that the law stipulates must be in black letter words and written out in full. And it is a style of legal reasoning that took root, particularly with positivism. If the law doesn't say it, it's not law. And there's another school of law that has developed which basically acknowledges the role and place of values in the Grundnorm of a country. Part of our Grundnorm is dignity, because we are from a past that was singularly lacking in dignity. And the courts haven't found much difficulty in interrogating whether a particular rule, a particular law, a particular conduct invades the entitlement to dignity. So we're not doing something over the hand, clandestine. Equality. Are the arrangements those that would advance our collective desire for achievement of equality? Not all countries have got that kind of provision, but we have it. It's an ideal that we would like to have a more equal society because of our past. So those values, we put them in chapter 1 of our Constitution. And we want people to approach the law having these values in mind. If there's a law that brutalizes people, Ubuntu will not permit you to do that. So it is not far-fetched. It is as much as you must go to the German Constitutional Court. You can see how they work in the requirement of dignity into their jurisprudence. And the European Court of Human Rights. So it's not something new. We're not alone in that quest to find a value-driven kind of jurisprudence. And there's ample space to be able to build Ubuntu into our jurisprudence. I don't think we did enough at the Constitutional Court, but we have tried. Much, much more can be done. And it's a notion of human solidarity. It's a notion of togetherness, of trying to support people's quest to live good lives and have dignity in their lives. And we all behave very terribly and we violate Ubuntu every day. But there's no reason why we should abandon it as a core component of our understanding of the law. It's an underlying value and not a single line rule, in other words.
Judge Moseneke, I've just been reminded, and see, I'm so enthralled and involved in this conversation that I didn't actually notice that we've been talking for about 2 hours with you, and that actually it takes some doing. So I think that the last, and I do owe this to the people who posed the questions, which I will combine, is how do we deal with violent crime? And on the one hand, how does one manage your own value system and your own belief system, and while you're sitting on a bench such as that of the Constitutional Court, particularly when it comes to, sorry, the difficult questions. Yes, and then
in
yeah,
2
and then
minutes,
I'll leave it. Yes, perfect.
2 minutes, because there is then to be 4 o'clock. I'm having another appointment coming up, but I had the privilege of talking 2 hours with the law school and with all of you, and I think I owe it to you being an alumnus of Rhodes, and I don't regret it at all. But it has been a full 2 hours now. Very quickly, yes. We have to create a more just society. We have to have norms that deprecate violence in all of its forms, particularly in the form of crime. And we must be united on that. And thirdly, we need effective institutions to combat violence. Those are the three. There are other things, but the combination, psychology of the nation, its tools and its instruments to combat, and us constantly saying it is not a done thing. The last question is so complex that I'm not actually going to do now. Let me just say that all judges, it's an old jurisprudential question, and the Really School of Jurisprudence has always talked about, Frank Thomas and others about, all of us bringing the inarticulate premise to our jobs. I think law professors do, I think judges do, everybody does. It is how well you screen off personal prejudice in the course of doing a very difficult and complicated job. I think good judges are known to be able to do that. They often have those screens. In Pretoria, we call them oorklappe. It's a kind of thing that sits right out there and gets you facing one direction and looking that direction. It doesn't mean there are no other directions, but it means you're very dedicated and determined to screen out prejudices and to produce good outcomes. Thanks.
Okay, I'm handing back to Professor van Coller. Thank you very much, Judge.
Judge Moseneke, I know we are pressed for time, and I will excuse you if I keep on thanking the rest of the people, but to you I would like to say, I think this conversation is absolutely emphasized what everyone knows about this book, and that it is definitely important and memorable. And I think you've given the readers incontestable facts. You've invited them to make their own assessments, and I really hope that everyone who attended today and listened to this conversation had the opportunity to do so. You've talked passionately about things that's really close to your heart, and I think that to all of us who listened here and participated, I think highlight to us, your great sense of occasion, and I think that you've got a brilliant eye for things that makes a better society. I mean, you started this afternoon by saying that I think we should all rise to things like goodness and just outcomes. So thank you so much. Thank you for the 30 books that you've donated to us. We are going to definitely, there's going to be a fight over who gets them. But thank you so much for the time that you've made available to us. We really appreciate that. And I think everyone, we've had almost 100 attendees, which is wonderful, and especially in almost last week of term, that students are already kind of anxious about upcoming exams. Good luck for your way forward, and if you've got other webinars at other institutions, but we really, really appreciate you taking the time to talk to us and to our students. So we will excuse you if you need to go while I thank the rest of the people, but thank you so much and good luck with the way forward. And this and as we've seen, you are retired, but as busy as ever. So thank you so much. We appreciate it.
Let me just say a little thank you to all of you, starting with you, Prof. van Coller, and to the law, to the the faculty, which has honored me in the past, and I much appreciate that. And my connection with all of you and the young people, Vuyani and Washington and Lisa and Sinamile, and it was a great structure you put in place. All other places call out their big guns professors, and you did it differently. I must just tell you, and it was great to have trust in these wonderful young people, to have the full and proper conversation with me, and they did. So I'm grateful, but I just thought you must know that you have the bouquet from me because you had enough guts to call out on your young people, to engage in other places. They call out their big professors to tell me what they like or don't like about the book. But thank you ever so much. Do stay well, and God bless.
Goodbye, Judge Moseneke. So to the rest of you, I would really like to also thank Ms. Charmaine Avery, our conference and events manager. Thank you so much, Charmaine. If we had to set up this webinar or this Zoom session, I wouldn't have been able to do that. So thank you so much. We appreciate that. To our Black Lawyers Association, Rhodes Chapter, the Law Student Society, the Natuko Legal Activism Society, and the Law Students Council. And last but not least, before we get to the rest, our 4 participants, our panelists, Zenamile, Washington, Vuyani, Lisa. You've asked brilliant questions. You've kept us engaged. We would have loved to carry on for another 2 hours. And I know you are anxious about upcoming exams and tests and still assignments due, and you made the time to actually engage with Judge Moseneke. And I think attracting about 100 attendees for this webinar was absolutely brilliant. So to the 4 of you, well done. To all our faculty staff that made time to also listen to this webinar. For the 30 copies of the book, we will see how we're going to distribute those. But I think our conversations today will really, I think it will be also invaluable in shaping the work of our faculty, of our students going forward. I think to conclude, maybe to assist you so that that we can produce students who are knowledgeable, intellectuals, skilled professionals, And above all, and I think Judge Moseneke has emphasized it really today, critical, but also caring and compassionate citizens who can contribute to economic and social development, an equitable, just, and democratic society. So to all of you, thank you so much. Ruzan, thank you so much for facilitating the question and answer session and for this whole idea. It was really facilitated by Professor Kruger. So Ruzan, thank you very much. And all of you, good luck with your last assignments, your test. Good luck for the exam and your future careers. We are looking out for you. And all of our attendees, thank you so much for attending this webinar.
Thank you very much, Helena. Thanks.
Thank you.
Thanks,
And have a good
Charmaine.
afternoon. So bye-bye,
Yes,
everyone.
bye.
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 Bye. Thank you.